Good afternoon, good morning, and good evening. My name is Paul Daly. I'm the University Research Chair in Administrative Law and Governance at the University of Ottawa, and I'm here to present the third in this year's Administrative Law and Governance Colloquium series on executive power. The theme for this year's colloquium is executive power, which has been the site of passionate debate in liberal democracies for many centuries. In recent decades, authority is concentrated in the hands of presidents and prime ministers, with voters increasingly looking to these office holders to give effect to their policy preferences. Questions about the scope of authority and accountability of presidents, prime ministers, and other executive officers have therefore become even more pressing. What powers does and should the executive have? Against which standards should these office holders be judged? And who should do the judging? In this year's series, we have been examining and will continue to examine the role of constitutional text and tradition, other governmental institutions, and civil society in granting and constraining executive authority, setting standards, and holding the executive to account. Today's guest is Professor Philippe Lagassé, currently an associate professor and the holder of the Barton Chair at Carleton University, where he teaches courses on Canadian government, policymaking, comparative defence policy, and military and strategic studies. He previously taught here at the University of Ottawa, and before that was an adjunct professor at the University of New Brunswick and McGill. He received his PhD in political science and government from Carleton University after completing a Master of Arts on War Studies at the Royal Military College of Canada. His current research, which we're going to talk about today, focuses on prerogative power in Westminster systems. Widely published on this and on the relationship between executive and parliament, including a book in 2023 on military affairs and legislative oversight. He also works as a senior associate fellow at the Royal United Services Institute and has been a consultant to the Canadian government, serving as a member of an independent panel to review options to replace Canada's CF-18 fighter aircraft. Philippe, thank you for being with us. So the idea is you're going to talk for about 20 minutes or so about your project, forthcoming book on prerogative powers. Then you and I might have a discussion, and of course, the participants are always welcome to pop a question in the Q&A, and Professor Lagassé will respond. And if he tries to avoid responding, I'll make sure he does. Je peux vous dire aussi qu'on est tous les deux capables de répondre à des questions, de comprendre et répondre à des questions en français. Alors, gênez-vous pas d'en soumettre dans la langue de Molière, si vous voulez. Philippe, the floor is yours. You have a PowerPoint, so I'm going to be off camera for a while. But again, thanks for doing this, and I'm looking forward to hearing more about this project.
Thank you, Paul, and thank you all for attending. Share my screen here. All right, are we looking good? All right. So as Paul mentioned, this is part of an ongoing research project that I have. It's a short project that began in 2019 to look at reform of the royal prerogative in Westminster states. Just as I was hoping to get my field work started in 2020, I think we all know what happened. And so the project has been somewhat delayed in terms of trying to meet people and speak with them about this in various capacities in the 4 Westminster states that I was studying. But the fieldwork has now been wrapped up, and I'm happy to present my preliminary ideas for the project and what I hope to be the book that'll come out of it. So project title, Tamed Crowns, ? Executive Ambivalence and the Prerogative in Westminster States. So what am I trying to do here? So very briefly, first off, why the prerogative? The underlying argument here is that when in a Westminster context, prerogative power offers a useful prism through which to understand executive power in the Westminster system. And drawing on the work of Mansfield and others, the underlying argument is that the formal vulnerability of royal prerogative, so as we'll discuss the idea that this is linked to monarchical powers, has to be contrasted with the informal ingerence of discretionary executive prerogative. And in making this argument, what I'm trying to forward here is that Westminster states, despite the subservience of the executive in their constitutional systems, are not all that different from other liberal democracies, including presidential republics, when it comes to the nature of executive power and the prerogative. And this is especially true in areas that we deem to be executive competencies, foreign affairs, defense, and intelligence. So what will I do here today? Very quickly, I'll go over the standard story of the prerogative. So this is effectively my null hypothesis, kind of what we're mostly all taught in constitutional law and other courses around the prerogative. How is it dealt with? What's it seen? How does it fit within the system? And then I'll contrast that with the reality of ambivalence of executive power in liberal democracies. I'll then focus in on what are specific types of Westminster style ambivalence. How does executive ambivalence look in a Westminster context? And I'll then go through my 4 case studies in order to give you a sense of how this manifests itself in these 4 countries. And it manifests itself differently depending on the country, interestingly enough, and we can get into why that is. And then I'll conclude with some observations that are over and beyond what I found in the research that could be avenues for future research or further discussion. All right, so what is the standard story around the royal prerogative? I think it's fair to say that it is, above all, seen as vestigial, and it's seen as vulnerable. That is, it's waiting to be displaced. It's waiting to end once Westminster states get their act together, once they become modern enough, contemporary enough. Eventually, this power will fade away, and it will be an interesting anecdote from the past, much perhaps like monarchy itself. When the crown disappears, as it may, given recent events in the news, who knows, we may reach a point where the prerogative itself is seen as something that is of a bygone era. But before we get there, and to understand why this is, let's look at the origins. And there's 2 things in particular that I want to stress here. So what is the prerogative? Where did it come from? What was its nature? It has to be understood in 2 prisms. First, as powers related to lordship. So these deal with the powers of lordship dealt with a lot of the king's relationship with subjects and with others. So when you look at the nature of lordship prerogatives, a lot of this like escheats and wardship and a lot of these more personal powers or personal relationships. There was, however, another branch of prerogative around theocratic kingship, using Martin Lauchlin's term here, which very much dealt with the king as the embodiment of the body politique and the idea of the king as having certain authorities with respect to the good of the realm, public order, good governance, the rule of law, and these types of things. Over time, as we moved out of the medieval era into modernity, we see a bifurcation here that follows this trajectory. You have privileges of the crown, and we still speak of it in this way. And then we also, though, note that the crown is the repository of sovereignty and has certain sovereign authorities. And when we move into the Elizabethan Stuart era in particular, we start again seeing this difference between ordinary and absolute prerogative. Now, this is an important distinction and one that I'd like you to keep in mind as we make our way through here, because ordinary prerogative was always understood to be subject to ordinary law. It was understood to be subject to Parliament. It was subject to the courts. It was always understood that the ordinary prerogatives of the crown that dealt with primarily its relationships with ordinary law and subjects and things of that nature was always subject to the common law. It was subject to judges. It was subject to Parliament. But there were absolute prerogatives as well. And this was the real touch point of the debate in the 17th century in terms of what were these absolute prerogatives. Now, when we say this, we tend to think of it in terms of absolute monarchy, but it really had another meaning. It dealt primarily with things that were seen as essential to the nature of the king as the embodiment of sovereignty and the defense of the realm. Okay. So it was seen as areas where courts and Parliament couldn't intervene because it was of a higher order. It dealt with the essential foundations of what was becoming the state, and it really dealt with matters of state. And in the 17th century, a good number of these conflicts that were arising dealt with what exactly were the boundaries there. So taking the case of ship money in particular, where on the one hand, seems like it's a taxation question, but It's also a question fundamentally about the defense of the realm, and ultimately the courts end up siding with the crown in that case. But as I'm sure all of you know, the real story of the 17th century through the English Civil War, but even earlier through Coke in particular, declaring that the king hath no prerogative but what the law allows. So the idea of subjecting the prerogative to Parliament and to the courts was central. And this ultimately came to fruition in the 1689 constitutional settlement, which, as we all know, established that all prerogatives of the crown, including what would have been known as absolute prerogatives, were subject to parliamentary control, parliamentary displacement. And in this era then of parliamentary supremacy, statute began expanding gradually until such a point where the prerogatives were very much reduced to a very small ambit. At least that's the way it's typically understood. Now, in the 20th century, of course, given that the executive now effectively controls the legislative process, statute is less of an effective means of controlling the executive. And then what have we seen? A return of the courts as being the primary area in which we control and delimit and try and constrain prerogative. So are we in the era of new Coke? That is the question. And I suspect that most would say yes. Now, in this idea, if we are in the era of now the courts constraining prerogative, and I don't think we need to look very far, Miller 1, Miller 2, the expectation that this ambit of authority will now gradually over time be reduced and shrunk to an even smaller area than it is today. But there's also a wider issue here within liberal democracy. And my fundamental claim here, absolute prerogative never really went away. It's still at the back of our minds, and it's still something that we wrestle with, even if we don't say it explicitly. Now, this quote from John Locke is often cited when it comes to the prerogative, and I want to return us again to this notion of ordinary versus absolute. So this is often taken as Locke saying that effectively the executive in some cases has to act outside of the law, or at least this is how American scholars interpret it, that without the prescription of law and sometimes against it, seems to imply that in certain specific circumstances out of necessity, the crown has to be able to act, and therefore it has this residual power in order to be able to do so. And this has very much therefore been seen as Locke saying, well, you need to be able to deal with specific emergencies, and that's what we're really talking about when we talk about prerogative. But read through the prism of this idea of ordinary versus absolute, I think what he's actually saying here is that, and he does note this in his analysis, there's a more fundamental law behind the ordinary law. And if we put it in the context of the debate around ordinary and absolute, this is very much in keeping with how the debate would have been framed at the time, that there is, in some cases, contrary to ordinary law, which is what Locke would have understood here, there is a more fundamental law around prerogative or absolute prerogative. He doesn't use it in these terms, but there's this understanding that the absolute prerogative, defense of the state, defense of the realm, necessity, emergencies, whatever it is, the crown retains something of that power. Now, Locke has had quite a bit of influence on how we understand executive power. And in particular, drawing on the work of Mansfield here, he makes the point that Locke's thinking really demonstrates an ambivalence that liberal democracies have around executive power. And what does he mean by this? His basic point is that the real practical, informal executive, so actual executive power, is far more powerful than the supposed theoretical formal executive. And far from being an accidental, this is by design. So what he's trying to say is, as much as we create our constitutional structures to have the executive being subservient to the legislature and in some cases the courts, the reality of the modern state is that the executive is a dominant power, and it actually has the ability to, in some circumstances, go beyond what we might consider to be its formal authorities. Now, I don't think we need to look very far to see the stretch of this influence in the United States. If you look at a lot of the recent literature around what the powers of the president are supposed to be at the time of the founding, and you contrast that with the contemporary presidency, you see that this is an office which is far more powerful than it might have formerly have been. And I suspect that in the months to come, we may see an even greater manifestation of that. So much so that the argument has been made that the US president is starting to look monarchical. Well, the reason that the US president looks monarchical is that it's an office that was ultimately still reflected the American founders' understanding of what the executive was as the crown. And it's really re-manifesting itself. We can see this in various ways, and there's been a lot of debate in the United States about whether or not this is appropriate, whether this is the correct way to read the Constitution, whatever it is. The reality is that we have a very powerful executive with core competencies in a separation of powers doctrine that enables a very strong executive, particularly in the area of national security and others. France is an even starker example. I won't get into many of the details here, but we effectively, under the Fifth Republic Constitution, have what a lot of French constitutional scholars would describe as a monarchical president, one that has a significant amount of authority, even though formally they are, it seems, subservient to the courts and to Parliament, at least through their government. Nonetheless, here again, we see a very powerful executive figure, one that seems to go beyond what one would expect. Ireland may be a tougher case, and I'm remiss to talk about this too much in detail, given that Paul is hosting this, and I don't want to get this too wrong. But even here in Ireland, we see, for instance, an external relations power, which is quite significant, deference to the executive on the part of the courts, in less of cases of clear disregard of the rights of the individual. This is not accidental. There is something about even the structure of executives in contemporary polities and liberal democracies in particular that emphasizes the importance of this office having these core powers. What does this look like in Westminster states? Well, I'm going to offer four types of ambivalence here based on the literature. The first is Timothy Endicott's description of what he calls the stubborn stain theory of the prerogative. Or of executive power in general, a paper that he wrote a few years ago now. And what he was describing is, within the UK, there's this frustration that the prerogative seems to persist, that it's very difficult to get rid of for some reason. In spite of the fact that it should be easy to remove, it's stubbornly clinging along. Endicott then makes the claim, well, the reason for this is that there's a necessity of an executive within modern states, and this is why it's doing so. But this type of ambivalence, why, if the prerogative is so easily displaced, why, if it should disappear, why, if it has disappeared in many areas, is it still clinging on in others? It's just not, despite this expectation that it is on the way out. That expectation has been lingering now for a good while, and yet stubbornly it is clinging on. Tom Poole has another ambivalence that he discusses around the prerogative, what he calls the prerogative two-step. And here he's discussing it in the context of the courts. But really, the idea here is that we've all, in all four Westminster states, reached a point where the courts agree that the prerogative is subject to judicial review, but that in certain cases, the courts will step back and be deferent in spite of that reviewability. So this is what he calls the two-step. Yes, the prerogative, like all executive power, is subject to review, and yet the courts will defer to the executive in particular areas. The third type of ambivalence, drawing on Lachlan again, is what's I'll term political right, which is his term here, which what he means effectively is a type of public law or a type of conception of public law where statecraft and sovereignty predominate, and considerations around what powers states need to have become a very important part of the constitutional fabric, even though we don't discuss them. And how that manifests itself in Westminster states, interestingly, is going to be around the popping up of political questions or this notion of certain inherent powers to sovereignty, and which may seem odd to us, but they do appear, particularly in the Australian case, as I'll discuss. And the fourth type of ambivalence, and I think this is the one that is the most interesting to me for future research, is Margaret Coyne's notions of these sweeping statutes. So as much as we talk about, yes, the prerogative can be displaced and it can be removed by parliamentary statute, what actually replaces it? And in a number of cases, what we're seeing is not actually parliamentary control of the prerogative through statute. We see vast grants of authority to the executive through the statutory process. And in a way, what we're seeing is the creation, in many cases, of statutory prerogative for all intents and purposes. Wide grants of authority, in some cases when it comes to individual rights with some limitations, but effectively in many instances, granting authority that's over and above what the prerogative even could grant, particularly in the area of national security. And so as much as we focus on the fact that statute is parliamentary and therefore this must be a demonstration of parliamentary control and parliamentary supremacy, we're making a mistake here between form and substance, where in effect the substantial powers of the executive are very significant, regardless of the fact that they're formally being granted by Parliament. What does this look like? In Australia, what's the standard story in Australia? The Australian case is very interesting because there's a general aversion in the courts towards the royal prerogative. This is really simply a manifestation of the fact that Australia no longer sees itself as British. It no longer wants to associate itself with the UK and British law in its reasoning. And therefore, the Crown prerogative is approached with a great deal of, I wouldn't go so far as to say disdain, but discomfort. It's accepted that it's there, but it is not given more credence than it should be, and it's the approach is to try and minimize its place within Australian law. And there's an overall preference for statutory authority. As well, contrary to New Zealand, Canada, and the UK, a greater amount of limitation on what are called third source authorities that, as you heard in an earlier seminar with Robert Craig, are considered to be part of the prerogative in some sense, but in Williams in Australia, a clear demonstration of trying to constrain the executive. So there is a standard story here in Australia that the prerogative is probably on its way out, that the authority of the executive is increasingly subject to judicial review, and it will be limited or subject to parliamentary control. Nonetheless, the ambivalences remain. Despite multiple efforts, the military and foreign affairs prerogatives in Australia persist. And even more interestingly for me, if you go back and look at a recent report by a joint committee on this in Australia, on military deployments in particular, not only do they recommend retaining the prerogative or retaining executive discretion when it comes to military deployment decisions, they go so far as to say, from this point forward, military deployments should be authorized under 68 of the Constitution, which is the Governor General as Commander-in-Chief power. So they're going so far as to say, not only should we not displace this power, but in order to insulate it from judicial review, we should make it a constitutional exercise through the office Commander-in-Chief, which is quite fascinating to me. Which leads us into the most interesting aspect of the prerogative in Australia, which is the nationhood power. Now, some of you may be familiar with this, but in effect, in a number of cases where the authority of the Commonwealth to undertake a particular action is not clearly identified either in statute, the Constitution, or the prerogative, the courts in Australia have had recourse to a nationhood power. Now, this can be understood in two ways. Either it is a question of federalism, that in those areas that are of national importance, not simply one of the states, then the Commonwealth government can act as a federal power and do what it must. But there's another side to nationhood. And I'm quoting here from the Tampa case, which was very much a clear indication of this. From then later to be Chief Justice Robert French. All those matters that are capable of being seen as of national benefit or concern, that is, all matters that benefit national government of the Federation. And this really has recourse to questions of sovereignty itself, powers inherent in sovereignty. So in the Tampa case, this was a question of whether or not the Commonwealth government had the authority to exclude migrants from Australia. It seemed that the statute didn't allow it in the way that it occurred. It didn't seem that the prerogative could be used here, but the nationhood power effectively saved the day. You come in and you say there is an inherent power to sovereignty in order to be able to protect your borders and do things of that nature. So within the Australian debate, this notion of an inherent power, a Lockean power, effectively a residual absolute prerogative remains. Equally interesting in the Australian case is the relationship between legislation and prerogative. So this is really, I think, the clearest demonstration, to my mind, of statutory prerogative. Australia is a legislative powerhouse. It legislates at an incredible rate as compared to Canada. But what's equally interesting in there is that high level of legislation, particularly in areas related to national security, is a real enabler of executive power. So the idea of legislation as constraining the executive has to be put to the test when we look at it in an Australian context, where in effect, the rate of legislation is so high, there's oversight, there's review, there's all these mechanisms in place, but legislation is effectively being used to empower the executive with significant powers. So as an example, the ability of Australian intelligence services to engage in criminality, which is something that we would shy away from, and yet in Australia, is part of its general ambit and what the Commonwealth Parliament allows the executive to do. Canada. Here again, the standard story is very similar. Steady advance of legislation, prerogative being reduced down to a fairly limited ambit, judicial review of the prerogative, as with any type of executive authority, established in Operation Dismantle in the 1980s, and reviewability for constitutionality. But we very much have the stubborn stain theory here. Military deployments, foreign affairs, elections, prorogations, whatever you want, the prerogative just seems to hold on. Despite the fact that it's been criticized from various groups, legislation has been proposed, we've put in various mechanisms to try and limit it, it still is holding on. Governments may even be critical of the prerogative when they come into power, and yet begin to see its value quite a bit after a while when they've been in power. And this is even true of the Conservative government, Stephen Harper, which came in seemingly pretty determined to delimit and really reduce the prerogative in core areas. And yet by 2014, you had Mr. Kennedy coming out and giving a full-throated defense of the prerogative in many cases. And even in the courts, as much as we think that the courts are going to be a source of control of the prerogative in Canada, and this is what I refer to as Turping at windmills. Daniel Turp, who made a valiant effort, I should say, in a number of cases to try and use the courts to limit the prerogative. The courts end up being quite different. And we have very much our own version of the two-step in Canada too. So Paul Daly's article, 2017, on the royal treatment that the courts give the Crown is notable here. When it comes to the prerogative, the courts tend to shy away. Now, this may be changing slowly in a number of areas, but we've seen a consistent pattern of judicial deference towards the prerogative in Canada. It's even used as effectively a signaling mechanism, whereby the courts, when they see that it's prerogative, have a greater tendency to either identify this as a political question, or to be more deferent, or to step back and say, this is probably an area where a degree of deference is owed. We also have political right ambivalence in Canada. As I mentioned, there's a number of cases where our political questions doctrine is starting to come together, and it seems to indicate that there's many areas where the courts don't want to wade in, that these are executive competencies. And just think of the most recent case around cabinet competences in Ontario. There seems to be this notion in Canada that the executive has some core competencies and privileges and powers that are not to be messed around with effectively by the courts, that it's up to Parliament to decide, but if Parliament's not going to do it, the courts aren't necessarily going to go there. And perhaps most interesting for me in cases like Catter, where you have the Supreme Court effectively saying that foreign affairs is a core, almost constitutional competence of the executive, making the point that this is almost, in a way, that we do have a separation of powers around this, and that there might be questions about what can actually be displaced by Parliament in this case. Finally, we also have sweeping statutes in Canada, fixed election dates that still give the first ministers an ability to call elections when they want. We have domestic military deployment legislation, which effectively allows the government to do whatever it wishes with the forces domestically. The intelligence services are empowered quite significantly in Canada, and when questions arise around their what they can do under the power, for instance, are they able to work with agents that may be deemed terrorist organizations in legislation, even if they can't claim Crown immunity? We amend the legislation in order to allow them to do so. So we also have a propensity in Canada to grant vast amounts of discretion to the executive when we feel that it's important to the state. United Kingdom, maybe one of the toughest cases for my thesis. Certainly the stubborn staying theory here, or the standard story, I should say, holds quite a bit here. There was a major push to begin to whittle down the prerogative from 2003 to 2019, succeeded in many cases when it came to the civil service and other areas. And as I mentioned, Miller 1 and 2 is really these clear demonstrations of areas where it seemed that the prerogative was on its way out. But there have been ambivalences here too. The stubborn stain remains. As much as 2003 to 2019 was noticeable in terms of the real turn within Parliament and the courts against the prerogative, it didn't succeed in every area, and the prerogative has popped back in a number of instances. We only need to look at the repeal of Fixed Term Parliaments Act as a kind of clear example of that. A prerogative that had been displaced that effectively gets revived by Parliament. And we can ask whether or not that is still a prerogative at that point. That's another question. But in a number of cases, the repeals or the pushback against the prerogative in the UK has been walked back. So the results of this 2-decade push against the prerogative in the UK have been quite mixed. The UK courts also engage in quite a bit of two-stepping, as Poole's thesis comes from, whether it's Bound Court or GCHQ. There'll be a lot of reviewability of the prerogative, but then in some cases, deference is owed. Now, we don't know if Poole would revise his thesis in light of Miller 1 and 2, but I think it's fair to say that deference is still owed in a number of areas. Political right also manifests itself in the United Kingdom. When necessary, the courts will, in some cases, arguably even invent prerogatives in order to make sense of what right the United Kingdom is relying on, or the Crown of the United Kingdom is relying on to do certain things. The two most famous cases of this are Northumbria and Third Direction. So Northumbria, the court is accused of having created a new prerogative, a sister prerogative to the war prerogative, where if the Crown can defend the realm against external invaders, then it must also have a sister prerogative to defend the realm against internal strife. So effectively, a prerogative to keep the peace. Now, a number of critics of Northumbria say, where did this come from? We have no record of this. This is the courts inventing things. But if you're looking at it from, Lockeanian political right, you're saying, well, yes, I mean, this is the courts trying to find a way to give the executive an underlying authority that most sovereign states would require. Third Direction is another interesting one, where what's being challenged is the statutory framework that allows MI5 to authorize criminality on the part of agents. And the courts here make a rather stunning claim, at least many would argue in the UK, that this was unprecedented, where the courts say, oh, well, not only does the statutory framework allow MI5 to authorize criminality or encourage criminality on the part of its agents, but the prerogative always would have allowed this. Now, suffice to say, if you're an adherent to the standard story of the prerogative, you say this doesn't work at all. The prerogative would never be able to go contrary to the law. That's the whole point, is that it's subject to the law. This would strike at the heart of what we understand to be the prerogative to be. And yet, if you look at it as a question of ambivalence and what powers states need, the UK courts in Third Direction are effectively saying, well, it would make sense that you would have the ability to defend the realm. It would make sense that you would have the ability to do this. Therefore, under the prerogative, you could have done it. So that's definitely a clear ambivalence. Sweeping statutes are a bit harder in the UK, but we do see them in a number of instances. Since 2019, use of ouster clauses, denial of citizenship, as we're seeing now with the Rwanda bill. The executive can use statute quite aggressively in the UK to get itself out of problems. Of course, we can get into this, but one of the challenges in the UK context is that the Parliament's quite a bit more independent from the executive than in the other cases. So less of an ambivalence there. Finally, very quickly, the New Zealand case is not as rich as I would have hoped it to be, but I'll deal with it quickly. New Zealand's an interesting case. Nearly all legislation binds the Crown in New Zealand, which is considered usually a prerequisite to displace the prerogative. So it binds the Crown in most instances. And yet, the prerogative still remains in a number of areas. It's out of sight, out of mind, and yet it still operates below the surface without getting much attention and is used as is necessary. New Zealand is also, as many of you know, through the work of B.B. Harris, really where third source authorities became quite prominent, at least in the legal literature. So we do see the fact that even in New Zealand, where you attempt to bind the Crown as much as possible, the prerogative still remains. And I'll never forget, from my own research, I was interviewing a minister a few years ago, and this line really is what motivated this project. The minister said to me, well, you know, my colleagues think that at the end of the day, no matter what happens, the royal prerogative will save them. And I said, well, that's an interesting formulation. What do we mean by that? And finally, there is two-stepping in New Zealand too, such as the Curtis case, where yes, you can review for legislation, but the executive retains discretion in key areas. All right. So that's been a lot, I know. Sorry to get it through so quickly, but I'll just conclude with some final thoughts. I think the most striking aspect of this research to me has been that we see the prerogative's vulnerability increasingly when it comes to individual rights. And I think that's always been the case, at least since the 20th century. When the rights of the individual are involved, then the courts are more willing to be aggressive towards the prerogative. They're willing to delimit it, or they're willing to say that if you interfere with the rights of the individual, then the executive has to be more constrained. When individual rights are not at play, though, deference is owed or deference is shown much more often, and this is interesting to me. And this is a theme throughout, that prerogative may be vulnerable when it comes to individual rights, but when you're dealing with matters of state that don't touch on the individual per se, deference is far greater. The other thing that really struck me from the research is just how much legislative power is an enabler of executive power. We tend to think of stronger legislatures and more legislation and more statute and statutory displacement of the prerogative as an example of legislative supremacy and the legislature making advances on the executive. The opposite is equally true. As much as the legislature can constrain the executive, it's important to know that legislative power and executive power can go together quite well. And the Australian case really is striking to me in this regard, where you see the executive controlling legislation and the Parliament in some cases legislating very rapidly in order to enable the executive to act. And I'll just give an example here as well, where in some cases an intelligence service will warn the government about a particular problem or an authority that they need, and within 24 hours, Parliament can pass legislation in order to give the intelligence services an authority that they require. So legislative power, legislative speed is not necessarily a limitation on the executive. In some cases, it's very much an enabler. The last one, or the last two, monarchism, presidentialism, they're both liberal types of regimes, and they both have to be understood as liberal democratic type of regimes. And returning to the Mansfield theory here, at the end of the day, we see ambivalence throughout liberal democracies, and we sister states. We look a lot more like presidential republics than we'd let on. And the last one, when it comes to the prerogative, we tend to privilege form over substance. Just because you displace a prerogative does not mean that you've reduced the executive's authority in any meaningful way. And then the question should really be, in many cases, what is it that we're trying to do? To constrain the executive or just get rid of something that we consider to be vestigial? Thank you.
Very good, very interesting and provocative as promised, Philippe. People can pop questions in the Q&A at any point, and Philippe will answer them. And if he doesn't, I'll make sure he does. I have one question for you to begin with, which relates to how you're defining the executive. Are we talking just about ministers, or at times you've also mentioned the security services bodies, which oh dear, I am talking to myself because we have lost our distinguished guest. I'm just going to pause the recording for a moment. I think he'll be back before too long.
Apologies
and he's back already. No problem. So I was asking about the what you mean by the executive. I'm getting that we're not talking just about ministers. You mentioned security services. You might have other parts of the executive branch that are in contemplation. But some of the concerns that people might have about enabling the executive might be tempered somewhat if those powers are vested in agencies that are at arm's length in some respects from central government. So I mean, the Privy Council office, Prime Minister's office, or the President's office. So what is the executive exactly for the purposes of this study?
So I consider to be both the political and the permanent. So that's the way I would divide them, really, not the formal executive, so not the Crown, Governor General, or the monarch, but both the political and the permanent. And where I find this interesting is, in many cases, returning again to this question of form and substance, in denying discretion to a minister and vesting it in a more permanent office holder, does that render that authority more susceptible to accountability? And in some cases, you would argue not necessarily, as we're seeing, in our own politics these days. In the absence of that ministerial control or that ministerial accountability, our propensity has now been, at least recently, to see a reduction in accountability on account of that. And when it comes to these different areas, we put controls around certain procedures and things of that nature, but I don't personally see it as a critical difference in the nature of the study. What we're talking about, to my mind, is whether or not we're dealing with the executive, be it an intelligence service or a minister. Does it in either case, are we focusing in on a distinction that may not be all that important when the state uses authority against you or for some purpose?
Yeah, I suppose I'm wondering, fair enough. I suppose I'm wondering as well if, in part, particularly with sweeping statutes, when they're passed and they empower executive officials in their political and permanent capacity, in many instances, these are responses to the realities of life. We live in a world which is more complex and requires more in terms of regulation, and our contemporary theory is that that regulation has to be flexible. So is it that there's something inherent about the importance of empowering executives, or is this just an inevitable consequence of having to respond to life in a complex world?
Well, I think it's both, actually. I think this is the question is as follows. In the book, I trace why is it that the prerogative debate, as it were, got very quiet in the 18th and 19th century. The Parliament was able to legislate and exercise a good deal of control, but also life was far less complicated. And the matters that the executive dealt with were far less complicated. Suddenly, after the First World War and during, is when we see the prerogative debate take off again, and the executive beginning to have recourse to these powers more explicitly once again in a much more interesting way. And it is effectively in response to the realities of modern life, as you were saying, but also the realities of modern statecraft, I think, which is really a little bit what we're hinting at here. So when the intelligence services are created in the UK under prerogative authority, and this is where the Dyson definition, I think, of the prerogative becomes very interesting, because anything that you do that's not statutory is prerogative. So prerogative ends up being this kind of catch-all power that lets you do a whole bunch of things, right? And that really is useful when you're dealing with modern realities and modern statecraft. So I think the two are actually very similar. It's not just the realities of modern life, it's the realities of modern sovereignty.
Good. All right. Now the questions are starting to flow. The first question's a general question. It's about what are the arguments for and against displacing the prerogative, and why is this debate important? I was going to ask a similar question, but in a slightly different way. And in a sense, in a sense, you've given a very good analytical account of prerogative and executive power, but there's no, you don't have an obvious normative position. I think we might just have discussed, we might just have touched on it in your response to the last question, but where are you on this? Are you in favor of the prerogative, or are you not, or do you maintain that you are above the fray as to whether it's a good thing or a bad thing?
I think it's fair to say I went into this and I've always had more of a bias of, if things aren't broken, why fix them? But really, it's an interesting question to me, because we've certainly coming out of the Iraq War, there was a lot of sense that this was a dangerous source of authority, or this was authority that needed greater control, or this was an authority that required greater parliamentary control, particularly in the UK. I mean, it's not by accident that you have, a slew of government reports and parliamentary committee reports in the UK saying this power has had its day. And the inspiration of the title of Taming Crowns is really a UK parliamentary committee report from 2004, Taming the Prerogative, this notion that this power should be subject to greater parliamentary control. But really, this is a little bit what I'm getting at when I talk about statutory prerogative and form versus substance, is the debate too often, I would argue, in answering the question. I think the question is bang on. In many cases, we say, oh, well, the prerogative is the problem. It's the fact that it's prerogative. And that's the issue. And I step back and say, okay, well, if you're going to replace it with exactly the same thing, or if you're actually going to replace it with even more authority, because that typically is what happens. We can talk about the current debate that we're having in Canada around something like defense intelligence. It strikes me that in many cases, when people want to displace the prerogative, they want to displace it with greater authority. We don't talk about it in those terms enough, right? That it's, in many cases, this is the debate that's actually happening is this notion that statute is somehow normatively better, when it doesn't necessarily lead to greater control, nor does it lead to greater accountability necessarily. So I'm even challenging the normative question in a way. I'm saying this is part of the problem, is that we're not actually talking about the right thing. We focus on prerogative when what we should be talking about is executive power.
Good. And that's a nice segue into a question from Michael Dunn, who asks about accountability. Is the reduction in accountability just a reflection of the degradation of ministerial accountability and responsible government, and the transfer from political to permanent is just a shell game to avoid accountability, either by design or a foreseen but unintended consequence? Lots to unpack there, but accountability is certainly important, and I get the sense that you're suggesting that if our focus is on substance rather than form, we might see more clearly the accountability issues that are presented by the way in which executives are being empowered.
Well, and this returns to your question about who's being empowered. I think what we're seeing is an evolution of the convention of ministerial accountability, where ministers no longer feel that they should be accountable for decisions that they had no knowledge of, or actions that they had no knowledge of. That again harkens back to an era when government was very small, and it was possible for ministers to we could entertain the fiction, just as we entertained it in the past, that the ministers were responsible for all acts of the crown because they advised the crown on everything. We maintain that fiction. We maintain the other fiction that ministers necessarily have to be accountable for everything that happens in their departments because it's a useful construct. Ministers increasingly are pushing back against that, I think, and politicians in general are saying, well, hold on. In some cases, if this is a purely bureaucratic problem, why should I resign? And the more, we begin to create these officers within the state that are empowered and the ministers are not necessarily tied to, there's going to be a great deal of resistance to having ministers. I mean, we can only demonstrate that hauling the head of the Public Health Agency before the House of Commons to sanction them is one of the clearest examples that we had in Canada of this, of where this is headed. And ministers are more than happy to let officials or throw them under the bus if they need to.
Yeah, where would you like to go with accountability? I mean, I just I'm thinking like everyone involved in these conversations, I'm always interested in what it means for areas that I know more about, and gas and electricity prices in Canada, they're set by independent commissions that have the power to set just and reasonable rates. I mean, this really sweeping authority, which is statutory, it was originally a common law authority. And that's a very sweeping authority. There's not much, a court is not going to interfere and say, this is an unreasonable or unfair exercise of that authority. Happens, but it's pretty rare. So, and there's no, sometimes you have override powers. Governments can override these regulatory decisions. So that's a measure of accountability, I suppose. But otherwise, it's not as if there's a whole suite of formal measures, and yet the system works, I would say relatively well, and people are happy with it. How do you think we should be thinking about accountability, and what sort of mechanisms we ought to have in place for these agencies that have often very broad grants of authority?
Well, I think it comes back to what we can actually realistically expect in the state. And as you know, there's been quite a bit of work on whether or not you can achieve this in the reality of the administrative state. And we're seeing part of this in Canada now, where what does accountability end up looking like? It ends up being these Schumpeterian democratic moves where at one point you just replace one set of elites by another set of elites, and then you wash your hands of it and you think that, okay, something's changed. And that may be just the very nature of just the size and expectations that we have of the state. And I'll leave it to you to tell us how we achieve, accountability from tribunals and administrative bodies and things of that case. When I'm looking more at kind of questions of matters of state and things like that, I think there is something lost in a sense when we remove the fact that ministers ultimately have to be accountable for prerogative. And this returns back to the normative question. Whereas a statutory authority can be granted to a particular officer of the executive, and ministers may claim that it's outside of their ambit or whatever it is, prerogative is still very much tied into the ministers. And there's quite a bit of rich literature around this. Where it can prerogative be delegated? Who exercises it within the state? But there is something about that power that still ties itself, as it were, to privy councillors. And does that help us achieve accountability? Perhaps it does.
Bharat asks on this theme, and last point on this for the moment at least. If I'm not mistaken, after 1968 in Canada, ministers became appointed more so on the basis of being reflective of the Canadian population, illustrative of diversity. I'm guessing geographic and other considerations. Do you think this may have practical ramifications in relation to what you're discussing?
I think what it points to is a lot of the time when we talk about on prerogative, we focus in on the reserve powers of the crown, and I would say that's a very limited way of understanding it, and it creates some confusion, because what we're talking about in those cases are more head of state function powers that are distinct from executive prerogative, that when it comes to matters of state and things like that. But I think what that demonstrates is convention, the political constitution, still has quite a bit of control, or is an effective means of controlling the prerogative. And we see this when it comes to military deployments in both Canada and the UK as well, where rather than try and create a statutory framework that would make things quite a bit complicated, you rely on the political constitution. You rely on the Houses of Parliament to have debates and votes and things like that to try and contain this power. And this is not dissimilar to Vermeule's argument, right? That at the end of the day, the executive is constrained by politics, not by law. And there's something at that when it comes to the nature of these crown powers.
Shifting gears a little bit, John O'Dowd, zooming in from University College Dublin, asks, apart from the Fixed Term Parliaments Act 2011 in the UK, which of course is now repealed, have you found other examples of government using control of the legislature to divest themselves, wholly or partly, of responsibilities they no longer want, perhaps because they no longer bring net political advantage? Judicial appointments are a recent example in Ireland, where they set up an arm's length commission to further reduce executive control over judicial appointments, and the Supreme Court upheld that against constitutional challenge. Are there more examples of that?
Yeah, it's not really what I was looking at per se, but it's a good question.
In Canada, it hasn't happened. Well, it has happened. I mean, it happened in Quebec after a political scandal and a tribunal of inquiry. They did depoliticize appointments there. There's federally, though, there was a challenge, but the courts rejected it. There was a challenge aiming to depoliticize, but the court said no. It's fine that the executive has this power.
Well, vice-regal appointments in Canada is a good example, where you set up a whole process in order to have better vetting of who we put in these positions, and the current government gets rid of it, much to its chagrin later, in terms of who ends up occupying the offices, but then recreates it when it comes to senatorial appointments. And will the next government retain that process? Maybe not. That could be, and there again, this is more of a constitutional power in Canada, but it's a good example of where there's a lot of going backwards and forwards when you're dealing more with the political side of the constitution there. And by the same token, we've seen conservative governments under the Harper government in particular holding votes for military deployment sometimes, except when it doesn't want to. Same with the treaty power. It will bring treaties before the House of Commons when it wants to, but then not when it doesn't want to, and keeping that at a policy level. So there's definitely a pattern of this, and I suspect even in Canada, how long are the fixed term elections acts going to survive, or just become oddities and features that provide some kind of guardrail, but really are not meant to be binding in any meaningful sense.
Sure. And I mean, to the point of the importance of politics in all of this, I mean, the current Canadian, well, the first Trudeau government certainly made a political hay from being able to put in place these independent appointment processes. That was something which they were able to use politically to distinguish themselves from their predecessors. To John's point, it was politically convenient rather than anything else. So some other questions here. I tend not to go through them chronologically. I try to weave them into the discussion as best I can. My colleague John Mark Keyes asks a question about the courts. And asks, are there any significant differences in how the courts review third source powers, common law or crown powers, as opposed to those generally recognized as prerogative? It might be useful to give a 30-second précis of the distinction analytically before getting into the whys and wherefores of how the courts deal with them.
Right. So very quickly, third source authorities, as they're typically presented, rely on a different type of authority, at least in theory. So whereas the prerogative or powers that that belong to the crown in its own right as the crown, as effectively the source of sovereign authority and things of that nature, third source authorities are said to derive from the fact that the crown in law is a person and therefore can do anything that any person can do. So when it comes to things like spending money, employing, contracting, things of that nature, it's said to be, well, this is just the crown acting as any other person would, right? And I would say, I think the clearest example we have of the difference is Australia, where when you get to third source powers, and the Williams 1 and 2 case are very much in sense about this, where do you need parliamentary authorization to spend money in particular areas? And the High Court in Australia says, yeah. You can't just say that you're spending money like anybody else. But in Canada, interestingly, we're fans of third source. We like it. We're comfortable with this. I mean, there's been recent cases, where the courts in Canada are saying, "Oh no, well, I mean, this makes sense. I mean, you have to have a general authority in order to manage your affairs, and this is just in keeping." So I would say it differs based on the jurisdiction, I think, and this is what is one of the Australian case is a real outlier for me in this research, just because it does demonstrate that they really view these questions differently. So I would say that in Canada, in the UK, New Zealand, I'm not seeing as much of a difference, but I'm happy to be corrected there. But I definitely see a difference in the Australian.
Still on the theme of the courts and the relationship between Parliament and the executive and independent agencies as well to some extent, Ed Cottrell asks, do you think the use and review of executive power to address the 2022 trucker convoy protests in Ottawa has been helped or hindered so far by the Emergencies Act? And that's the Emergencies Act is interesting. On the one hand, it grants powers that might look sweeping, but when you go back and you look at the context and the legislative history, it's pretty clear that Parliament was trying to tie the executive down and narrow the scope for federal emergency powers. And then we've had a use of the Act, and we've had parliamentary debate, and of course the declaration was revoked before the Senate had a chance to vote on it, because there were rumblings that the Senate was going to vote against. We've had an independent commission of inquiry with a slate of recommendations made by Justice Rouleau. And we've had judicial review in federal court coming to the conclusion that the use of the Emergencies Act was unlawful, subject to an appeal, of course. So that's a fertile source of analysis potentially.
It is, and I think the Emergencies Act tells us lots of different things about this, or the use thereof. firstly, getting back to politics and the nature of constraint, I think this was a clear example of the executive, when it needs to act, will come up with some way of interpreting how it can act. And then later on, it'll deal with it after. And I'm always reminded this when I was in New Zealand in October. I had a good interview where an interviewer was telling me, there was a situation in which the New Zealand Defence Force was assisting police, and there was somebody dying in the street, and they were saying, why can't the New Zealand Defence Force should just go in and get them? And the New Zealand Defence Force said, well, we're not indemnified. We can't do this. And the answer back was, just do it and we'll deal with the problem later. And, there's this contrasting notion of like how the executive should act. Should it always, we say rule of law and we want it to be very strict, and then we end up in situations where, we just need action and we'll realize that we'll kind of deal with it later. But I think the other thing that's fascinating to me about the Emergencies Act is it kind of reinforces the normative defensive prerogative, which is you've overconstrained yourself or put yourself in a framework. You couldn't anticipate things that would have occurred. And I've written a little bit about this recently. When the act was drafted, you couldn't have known that a province would refuse to act. You would have assumed that a province would do something in this type of situation. And the statute is effectively assuming that provinces will defend public order. The question then becomes, what happens when they don't? And prerogative is meant really to fill those gaps, right? And I think a good case can be made, I'm increasingly of this view, that the Northumbria prerogative to keep the peace probably still endures or has to endure, because without it, we've created a huge gap in federal legislation here and in federal authority. So I think there probably is a prerogative, or there should be a prerogative, to deal with cases of public order that fall below the CSIS definition of national security in the Emergencies Act. Otherwise, we're arguing that we've left Canada basically defenseless against this type of instance when the provinces refuse to act. And it's really fascinating to go back and read Northumbria, where the justices and the law lords are saying, well, it's inconceivable, right, that we wouldn't be able to defend public order. And in a sense, this is if you're pro prerogative and you're saying don't mess with it unless you really need to, the Emergencies Act is a good example of, well, okay, the best of intentions, you're not going to be able to account for all uncertainties. There's going to be some cases in which you don't know how things are going to happen, and it's always useful to have that residual authority in your back pocket.
Yeah, I suppose as a lawyer, and the old proverb about the man with a hammer thinking every problem is a nail. I tend to like the idea that there can be legal resolutions to these questions, rather than them being matters of political right and might and wrong to be settled in the political arena. But I guess that's what happens when we come at these things from different angles. And I absolutely take the point that sometimes a statute might be so constraining that it might prevent the state from responding to a clear and present danger. Two last questions in the list. One from Martha McDougall asks about what the authority for Canada's armed forces is. What's the relationship in terms of the use of military force by Canadian officials as between Parliament and the prerogative?
So this is a question that's a theoretical one, but still fascinating to me. If you read the National Defence Act, it doesn't say that it's creating the armed forces. It recognizes that the Canadian Armed Forces are the forces of Her Majesty raised by Canada. And you say, well, what does that mean? And it seems to indicate that you almost don't want to deal with the question. You don't want to ask, where do these armed forces come from? Because when you go back to 1689, you'll recall that the limitation on the prerogative in 1689 is a limitation on the prerogative to maintain a standing army in peacetime, not in war. So the power to raise armed forces for the defense of the realm in non-peacetime remains. The Royal Navy, another example, has always been raised and maintained by the Crown after 1689 as well. So the question in Canada would be, are the forces raised by the Crown, or are they raised by Parliament? I think it's the safe answer is to say both. They're funded by Parliament, but they're raised by the Crown, and Parliament can offer its sanction. But it's a fascinating question in the Canadian context, simply because it does turn around this larger issue of where does authority for command ultimately lie in Canada. And it's the next project I'm starting later. Is it statutory? Is it prerogative? I would argue it's probably prerogative, but then you get into this other interesting thing around the Australians now turning to Section 68 of their constitution to try and say there's some inherent authority in the commander-in-chief power. And to my mind, it's questioning, what is Section 15 in Canada of 1867? What's it actually telling us? At the time, it was a colonial instrument. You wanted to make sure there was a common chain of command between imperial forces and colonial forces, and therefore the Queen had apex authority over the military. What does it mean today to say that the Crown is commander-in-chief or has the power of commander-in-chief in Canada? Is it just a useless bit of the Constitution? Or does our living tree allow us to say, well, at the time it was a colonial power. Today we recognize that there's inherent authority, as the Australian Parliamentary Committee is kind of hinting at.
Well, we await with great interest this subsequent project. Philippe, last question in the list, and then I suppose we'll let you get back to finishing this project and thinking about the next one. It's from Michael Dunn, and he asks, I'm not sure exactly what you were talking about when this question came in, but he asks, does this harken back to the 17th and 18th century law and reasoning around public office holders and control by the courts? And of course, office holders, very significant feature of the history of the state in the common law tradition. Good book on this by Jason Grant Allen, looking at the notion of office. What do you think? Is this something you've had to take a position on, or what?
I'll answer it this way, which is that when you look at the standard story of the prerogative, or I should say even the standard story of executive authority in the Westminster system, what's the key case, right? What's the one case that we say this is the case that should solve all cases, and it's Entick versus Carleton. And you say, well, I mean, the rule of law demands that there be legal authority to do things. And on account of that, or you need some kind of justification, right, in order to act. And as much as Entick versus Carleton is kind of held up as this kind of keystone case, the reality is far murkier in practice, particularly when it comes around the prerogative. And so I would say that here again, even when it comes to the powers of that office holders exercise, our expectations around, or our rule of law expectations around this are the bar has in a way been set too high. We do allow in some cases, as we're seeing around the Emergencies Act, control by the courts of executive actors, but control by the courts is always ex post facto. And it's this returns back to the discussion that we were having earlier. Yes, the courts control public office holders. Yes, they ultimately are answerable for their decisions. But the rule of law expectation that they will be highly constrained by the specific authorities given to them is tempered somewhat by large grants of statutory authority and by the prerogative itself. And I think that's just the reality that we live in today.
And I think that's a good place to close the discussion out. Thank you very much indeed, Philippe, for sharing this research with us. Interesting and provocative, and I think I speak for everyone attending live or watching later when I say I'm very much looking forward to the book. So thank you very much for having been with us. We'll be back with Ariane Vidal-Naquet for the last in the series for this year on March 27th. Until then, thanks everyone for your attendance today, and see you again soon.
Thank you, Paul.